Hello everyone, my name is Tariro Chirinda. I 3-2 Herbert Chitepo Law School. My facilitator for jurisprudence is Mr. Maposa. So I am going to be taking you through the topic legal positivism. So by definition, positivism is from the Latin roots positus, which means to posit, postulate, or firmly affix the existence of something. So legal positivism is therefore a school of jurisprudence whose advocates believe that the only legitimate source of law are those rules, written regulations, and principles that have been expressly enacted, adopted, or recognized by a government entity or political institution, including administrative, executive, legislative, and judicial bodies. The basic question to be asked when talking about this theory is, what is law? Is it written? Where does it come from? So legal positivism is the only theory which answers those questions. So in short, we're just saying that legal positivism is different from the natural law theory in the sense that it states that there is no relation between law and morality. So I am going to talk about the history and development of legal positivism and its proponents through different philosophers or positivists from the classical up to the modern theory. So this theory was developed to a greater extent by jurists such as John Austin and Jeremy Bentham around the 18th and 19th century. Subsequently, this school of thought was taken forward by influential jurists such as Hart, Kelsen, as well as Raz. And these jurists have significant differences in their views, but the common idea is that they analyze law as it is. Therefore, legal positivism school only aim to identify the law as it is laid down by the superior body and not how it should have been. Moreover, the common theme between all the jurists of the legal positivist school was that they kept law and moral principles on a completely separate footing. The legal positivists believed that law had no relation to moral principles. However, they were of the opinion that law often reflects the morality of people that it controls. Therefore, they say that the law does not have to be in consonance with the principles of morality and ethics, and rather, law is what is laid down by the superior body. Depending on the weight given to the moral principles, legal positivism can be divided into positive positivist and negative positivist, where positive positivists such as Hart were of the opinion that the moral principles do exist in the universe, but it is required for the law to abide by them. Then negative positivists are those who completely negated the existence of the principles of the ethics of morality. Thus, they do not believe in the existence of moral principles. And such jurists includes John Austin. Therefore, we can clearly infer that the legal positivist school does not completely negate the existence of the moral principles, and to some extent also articulates that the law may be based on the principles of morality and ethics. So the first philosopher is Jeremy Bentham, an English jurist, and is regarded as the greatest figure in the history of the British legal positivism. He defined law as the command of a sovereign backed by a sanction. So in simple terms, we're just saying that Benham's definition of law can be given as the will of the sovereign. He was of the opinion that rules which are derived exclusively from the commands of a sovereign authority from the law of the land. He said that law, which is the will of the sovereign, regulates the conduct of the people to which it applies. So Bentham can be regarded as one of the classical founders of the legal positivism. However, Benham's concept of sovereignty is not absolute in nature and can be restricted to a certain extent, as he is of the opinion that sovereign can, by his own will, limit his own powers by entering into agreements with certain external agencies, which would put restrictions on the power of the sovereign. Another important feature of law, according to Benham, is that it should be backed by sanction. That means to say that a command should be backed by sanction. Therefore, the will of the sovereign must always be backed up by sanction for it to become law. Benham talked about the positive as well as the negative side of the sanctions. Unlike Austin, who only talked about the negative side, Benham was of the view that rewards should be given to people who follow the law, while punishments should be inflicted upon those who break the law. This was to encourage people to abide by the laws, moreover, to discourage people from breaking the law. It is also of a paramount importance to note that Benham also developed the utility theory, which contributed to what the law ought to be. He had a pain in the pleasure thesis. According to Benham, any person is governed by two masters, that is pain and pleasure. Therefore, every law should be promulgated by sovereign in such a way that it diminishes pain and maximizes the pleasure of the people who would be governed by that particular law. Along with the principle of utility, Benham proposed the codification of laws and stated that the uncodified body of rules that was part of the English law was not worthy of being called as law. So in short, we are just saying that Benham developed what we call the command theory, in which a command has to be backed by a sanction for it to become law. And also he formed what we call the utility theory, which is associated with pain and pleasure, whereby the law has to minimize pain and maximize pleasure to the people. So we move on to another positivist who followed after Benham, and he is also of the classical legal positivism, and this positivist is by the name John Austin. John Austin was a prominent British legal philosopher who takes the credit for formulating the first systematic alternative to both natural law theories of law, and John Austin formulated the first systematic alternative to both natural law theories of law and utilitarian approaches to law. Austin's theory of law is form of an analytical jurisprudence. So we are saying that John Austin is more like a discipline of Benham. He just had to expand the command theory, which was developed by Benham. So Austin contributed to the legal system that law is laid down by the command of sovereign. Law is strictly separated from justice. Instead, by considering it as good or bad, is totally based on the power of sovereign. Austin also embraced the idea of law being sovereign. Being a sovereign commands, just like Hobbes and Benham before him. So Austin's jurisprudence was shaped on the lines of Benham's thoughts, but Austin was in a manner whatsoever Benham's intellectual clone, and Austin had some differences from what Benham had stated during his command, when he formulated his command theory. So the first thing is to talk about Austin's taxonomy. Austin attempted to classify all that he opinioned was the proper subject of jurisprudence, adding to the laws of political sovereign. This was inclusive of divine law, moral law, customary law, laws of private associations. As per Austin, only some of these laws are what he called properly so-called laws, while the others are by analogy, meaning laws only in the figurative sense. Austin believed that laws by analogy are not law per se, but are positive morality. This is inclusive of rules which are of non-obligatory nature as rules of social etiquette, moral rules, etc., etc. Austin also made a distinction between laws properly so-called and positive law. According to him, there exists primary two kinds of authority in Austin's legal universe: the authority of the Christian scriptures and the authority of the political superior. Divine law is understood to be that which is said by God Himself for the creatures. The scriptures are known to be the source of divine law. So, on the other hand, the political superior is the direct source of human law, properly so called, which Austin termed as positive law. As per Austin, positive law was the exclusive concern of jurisprudence, whereas the law of God was primarily the subject of theology. Austin went further to distinguish laws set directly by political superior, or what was understood to be as sovereign, from the laws which were set by private citizens in quest for their legal rights. Austin also defined positive law as comprising of commands of a political sovereign backed by sanctions on the ones who disobey them. There are three primarily key constituents of the concept of law in terms of the Austinian's theory of law. The first one is political sovereign, then the second one is command, then the third one is sanction. So in short, we are just saying that Austin, unlike Benham, makes it clear that a sovereign is not a particular person or persons, but also the constitution that embodies supreme authority. So for a command to be law, it must satisfy some requirements. For example, a command must be backed by a sanction for it to become law. That's in terms of the Austinian's theory. So Professor Raz, in his book The Concept of Law, acknowledged that Austin's sovereignty has got two elements, namely positive elements, which entails that law is a command of sovereign when it is obeyed by a bulk of the society. And the second element is negative, which limits that sovereign is not under any, which entails that sovereign is not under any duty or obligation to obey the law. So Austin also attempted to point out the differences between positive law and positive morality. As per Austin, moral rules that resemble positive law make up positive morality. There are various rules of positive morality that are coextensive with rules of positive law. For example, rules against killing someone, stealing, raping, assault. As per Austin, whenever there is a conflict between positive law and positive morality, positive law would prevail. Though Austin was a man who maintained that sovereign is bound to obey the divine law, he considered it to be a moral duty and stated that even if the sovereign ever legislated against the divine law, it will still be law. Austin further adds that any other view in his regard would not only be wrong, but it would be pernicious, as it would lead to archaism. So we move on to the criticisms of Austin in Benham's theory. So the first one is to say that the view of John Austin in Benham that law is a command of the sovereign backed by sanctions, yet certain shortcomings, therefore was criticized to a certain extent. According to Austin, the sovereign is supreme and owes allegiance to nobody else. However, the concept of international law is a restriction on the external sovereignty of the determinate superior. So the sovereign has limited powers due to the rules, regulations, and treaties which form part of the international law. Therefore, the idea of sovereignty is supreme and absolute is challenged by the concept of international law. So we're just saying that the idea by Austin and Benham that the sovereign is supreme is challenged by international law, which has got the treaties and regulations which limits the powers of the sovereign. Moreover, the fundamental rights given to the people restrict the powers of the sovereign and therefore are a challenge to the internal sovereign of the determinate superior. The sovereign has to exercise its powers according to the fundamental rights of the people, and therefore the sovereign cannot breach the rights of the people while exercising its power. Therefore, fundamental rights also challenge the absolute character of sovereignty. John Austin and Jeremy never talked about the concept of legal system, which is prevalent almost all over the world in this modern era. They only talked about the concept of sovereign, and the sovereign being the source of laws. The concept of legal system was never discussed, which also limits Austin and Benham's command theory. To add on, the idea of sovereign given by both jurists give rise to an autocratic regime. Since the sovereign is supreme and has absolute powers, since the sovereign does not owe any allegiance to any other person or group of persons, it has the power to act as it wants, and therefore there are no restrictions on the powers of the sovereign. Therefore, the concept of sovereign gave rise to the idea of autocratic regime. One of the primary shortcomings of the two jurists was the fact that they regarded sanctions as the only basic source of law. They believed that the existence of law is not possible without it being backed by sanctions. Therefore, if the will of the sovereign is not being backed by sanctions, it will not be called law. So we are moving on to the next or the third positivist by the name Hans Kelsen, who formulated what we call the pure theory. So Kelsen is the purist of legal theory. He excluded sociological and psychological investigation and anything which might be considered as foreign to the essence of law, and maintained the division between law and morals. Hence, according to him, concepts and methods that cloud legal theory should be eliminated. Kelson's theory of law is a system of norms authorizing their own creation and seem to remove the human element from law. He supersedes Austin's vision of law as an expression of the sovereign political power, with the idea of law as a self-sufficient system of rules and norms. His theory looks at the signs of law, which would describe conduct as legal or illegal, or making statements about legal rights and duties as objectively as possible. By definition, Kelsen meant what legal and illegal actions are and what they entail in the form of understanding delicts, which are action which requires sanctions. So he then formulated his theory as a system with several components, parts linked to them as follows. Number one, law as a primary norm that stipulates its sanction as direct to officials. So for Kelsen, a norm is a descriptive of law. Thus, a norm is an odd statement that officials use to apply the necessary sanction if Y commits a delict. Then the second component is that law is a system which are self-organizing, that is, they are of hierarchy and validity. So Kelsen is of the view that each norm draws validity from the validity of another higher norm, which in turn derives its validity from still higher norms within the system, and hence he portrays the status of norms as hierarchical. Then the third component is that of concretization. Kelsen notes that law is distinguished from the fact that it regulates its own creation, that thus the creation of legal norms is authorized by other legal norms and by means of the term of concretization. Then we move on to the fourth component, which is the grant norm. So the grant norm is the starting point of the chain of legal norms and is the original source of authorization for the decisions and actions taken by a system. So Kelsen cohesion of main so for Kelsen, coercion of men against men must be formulated in the terms of conditions in the manner laid down in the historically, which is the constitution. So the grand norm is a presupposition of the validity of constitution or a monarch, and is for this reason he described it in his late writings as fiction. However, this norm issue highlights Kelsen's weakness of his pure theory. So if a norm is derived from another norm, the question that arises is then where the first constitution came from and who authorized it. So although Kelsen attempts to justify that the first grant norm operates a step back to give validity to the first constitution, thus the grant norm is effectiveness or acceptability. Unfortunately for Kelsen, effectiveness is based on the factors he seeks to exclude, which are morals, political, and ethical considerations. So I have a few cases where the pure theory by Kelsen has been applied, and the first case is Madzima Mombe versus Letnabes. The case tested the validity of the UDI under the Smith regime. According to the 1961 Constitution, the UDI was clearly illegal. The court held it was not yet in a position to determine whether the government had met the effectiveness test under Kelsen's theory. So, the Kelsen's theory in this case could not apply since it was not effective. We also have another case of Ara versus Ndlovu, where it was held that Smith had met Kelsen's test of effectiveness and was now a lawful government. On the other hand, in City of Harare versus Robo, Tendai BT raised the Kelsenian argument in defense of his client, City of Harare. In the City of Harare case, the City of Harare was run by an unlawful commission. The court had declared the commission unlawful. So Jobo argued he could not be dismissed by an unlawful body. The Kelsen argument was in the following direction. The commission was the only body running the city. It was effective in control. Its actions had to be regarded as lawful. So in this case, the court upheld the Kelsenian's theory by saying that it was effectiveness. We also move on to another positivist who tried to uphold the legal positivism concept of jurisprudence. And this positivist goes by the name Hart, who formulated the concept of law. So Hart can be regarded as one of the modern legal positivists. So if we have seen that a distinctive doctrine of 19th century positivism was imperative law, theory of law, which stated that law is essentially an instrument of law and morals. Hart maintains the separability thesis. Thus, external features such as law, morality, or transcendental ideas have no relation to law. He is of the view that an evil law can still be law. Hart therefore rejected the works of Austin. So Hart rejected the works of Austin as inadequate to the nature of law. He goes on to list the defects in Austin's theory as follows. Number one, laws are not commands. They are not like orders backed by threats. Then number two, the concept of command fails to account to the range of application of law. Then number three, an order backed by threats cannot account for the mode of origin of law. Then number four, the concept of sovereignty depends upon the habit of, by Austin, depends upon the habit of obedience from the subject. Yet this fails to explain why laws continue to be observed by the original legislator. Thus, the notion of the habit of obedience by Austin is inadequate. So, Hart's own concept of legal system comprises of obligations as an essential element. A society requires a system of rules in order to protect persons, property, and premises. It therefore developed a conception of law based on rules, namely primary and secondary rules. Valid rules must be accepted by the majority of the community, including administrators. So, primary rules, which are rules of conduct, are based on the obligations to perform or to abstain from some acts. They also include the proper running of the society, for example, paying tax. However, primary rules alone will not suffice. Rules must contain restrictions. For example, the use of violence must be able to deal with those who reject them. On the other hand, secondary rules, which are empowering rules, confers power to change, modify, or enforce primary rules. Hart separates secondary rules into three, namely rules of which are rules of recognition, rules of change, and rules of adjudication. So rules of recognition are there to remedy for the uncertainty of primary rules, and it governs the validity of all rules. Thus, for a rule to be valid, there is need for recognition. Then rules of change, they remedy the static quality of the regime of primary rules, and the rules of change, they range in complexity. Hart emphasizes the close connection between rules of change and the rules of recognition. Where rules of change exist, rules of recognition will necessarily incorporate a reference to legislation as an identifying feature of the rules, though it needs to refer to all the details of procedure involved in legislation. Then we move on to the rules of adjudication. These ones, they empower individuals to make authoritative determinations of the question whether on a particular occasion a primary rule has been broken. They govern the election of the procedure of the judiciary. Rules which confer jurisdiction will also be rules of recognition, identifying the primary rules through the judgment of the courts, and these judgments will become a source of law. So I am done with positivists who tried to define what legal positivism is in pertaining to legal positivism. So we also have another theory which is linked to legal positivism, and this is the separability thesis, which is an extension of positivism and is an assertion that distinguishes legal positivism from the theory of natural law. The separation thesis captures well Hart's idea that there is no necessary connection between law and morality. However, Coleman is of the position that separability thesis is inadequate to distinguish legal positivism from natural law. It is not essential to legal positivism. So Coleman is of the idea that the separability thesis is not essential when it comes to legal positivism. Therefore, Coleman concludes that the hallmark of positivism is an existence on conventionality of law, not the insistence of the separation of law and morality. Then I'll move on to talk about another positivist by the name Joseph Raz, pertaining to exclusive positivism. So according to exclusive positivists, it is not possible to incorporate moral principles into law. Joseph Raz, one of the 20th century's most influential legal philosophers, is an exclusive positivist who believes that the content of law cannot be understood solely through social facts, not moral principles. Raz's arguments depends on his conception of a source thesis, which says that all law is a result of social facts. Essentially, all laws can be traced back to its source and the social factors around it. That is, a law has authority because it was passed by Congress, not because it is some moral component. His argument for exclusive positivism builds on the view that all legal systems claim to have genuine authority. The last part that I'm going to present is about the criticisms of legal positivism. So number one, legal positivism has been argued to be concerned merely with a set of facts and lacks in unifying reference. To ignore ought in the context of law is to ignore the motivation of the legislation. The result is inadequate in the essence of law. So legal positivism results in downgrading the ideal of the concept of law. However, we can also say that legal positivism is a contribution to jurisprudence. For example, positivism has emphasized the autonomy of the law and stressed on the importance of the study of law as a subject on its own rights. It also pointed to the need of rational investigation to legal positivism. So in conclusion, we're just saying that legal positivism mainly focuses on the separation of law and morality. It views that there is no link between law and morality. So it can be divided into two, namely the exclusive and inclusive legal positivism, where exclusive legal positivism states that no social facts about behavior and attitudes fix the content of law, while inclusive legal positivism is of the position that only social facts determine the determinants of the content of law. So, as we have seen through the works of different and various positivists, which I have tried to highlight, which includes Benham, Kelsen, Austin, they tried to define what legal positivism is. And also, they have various views pertaining to legal positivism. So this can be seen through the classical up to the modern legal positivism. So it should also be noted that legal positivism is connected to the principle of separability. This is which I have tried to point out during my presentation. With this, I'll just say thank you.